Good morning. I'm Mindy Baker. In April of 2019, my client, Chef Eagle, was 2 months away from opening his dream restaurant. As he made the final touches to his menu, he added his creative take to two dishes inspired by growing up in Omaha. The Reuben sandwich is said to have originated there in the 1920s, and the runza may be the most well-known fast food item in local Omaha culture. It is essentially a bread stuffed with beef, sauerkraut, or cabbage, onions, and seasonings. Chef Eagle did extensive recipe testing to combine these two local favorites and developed a roux run, a Reuben-style stuffed bread. He also wanted to add a dessert that paid homage to Omaha. He had his grandmother's blueberry pie recipe, which was a favorite, but he wanted to add a unique take. Nebraska is known for their corn, so Chef Eagle did extensive recipe testing once again and settled upon a cornmeal crust with a blueberry and sweet corn filling. He found parts of recipes online and combined them with his grandmother's recipe, and he ended up with what he labeled Omaha blueberry pie. It was grandma's, but better. The pie quickly became a customer favorite, and Chef Eagle was invited to demonstrate his recipe for the pie on the NBC Local Morning News. This was in July of 2019, a month after the restaurant opened. A few days later, Chef Eagle received a letter from a lawyer representing a chef in Omaha, claiming that he had stolen Chef Husker's intellectual property. Chef Husker claims that my client, Chef Eagle, misappropriated his trade secrets for Omaha blueberry pie. This is a case of two different chefs in two different states making two similar blueberry pies involved in one unsubstantiated lawsuit. After hearing the facts, it will be clear that there is no evidence to support the defendant's allegations. First off, my client has never met or worked for Chef Husker or with anyone who had access to his version of Omaha blueberry pie. Second, my client spent countless hours perfecting his version of the pie. He tested different flavorings like red wine, almond extract, lavender, lemon zest, cinnamon, different thickening agents, cornstarch, arrowroot, tapioca, and he even experimented with vinegar, bourbon, and vodka in the crust. There is evidence of his extensive research and notes and recipe testing before arriving at his version of the Omaha blueberry pie. Third, even though Chef Eagle was not privy to Chef Husker's recipe, the plaintiff's recipe is not copyrightable anyway. In order for there to be a basis for copyright protections, a recipe or formula must be accompanied by substantial literary expression. Mere listings of ingredients, as in recipes, formulas, compounds, are not subject to copyright protection. The plaintiff's recipe is composed of ingredient listings and rote baking instructions and lacks necessary literary expression to be copyrightable. It has also never been published in a cookbook, which can be copyrighted if the author adds original literary commentary. Ultimately, Chef Husker's recipe and procedure for his blueberry pie are well known in American cuisine. They're fairly basic and could easily be discovered by others. A quick Google search for blueberry corn pie recipes leads to over 5,900,000 results. There is nothing novel or proprietary about the plaintiff's recipe or process, just as there's nothing novel about my clients. A Google search for Reuben stuffed bread yielded over 1 million results, and there were even multiple recipes for Reuben runzas. Very few recipes are unique. To prevail on a claim of copyright infringement, a plaintiff must prove ownership of copyrighted material and copying by the alleged infringer. The plaintiff has not done so. Fourth, the plaintiff did not patent any unique methods or inventions for preparing the Omaha blueberry pie. Even if he had tried to apply for a patent, it would have been hard to prove novelty, and his recipe would have had to be made public. Fifth, the plaintiff did not reserve the trademark Omaha blueberry pie through the U.S. Patent and Trademark Office. A trademark would have only protected the title and not the recipe. Generally, names and labels could be trademarked, which is the typical scenario for protecting food item brands. The sixth and final point is that the plaintiff did not take precautions to keep his recipe a trade secret. A trade secret is insider knowledge that gives your business an advantage. A common example is the Coca-Cola formula. An unpublished recipe can be protected under trade secret law. The plaintiff would have needed to use non-disclosure agreements with his chefs, contractors, manufacturers, distributors, as well as anyone else who came into contact with the secret recipe. But Chef Husker did not take any steps to protect the secrecy of his recipe. Your Honor, we are asking for a motion to dismiss. As stated earlier, this is a case of two different chefs in two different states making two similar blueberry pies involved in one unsubstantiated lawsuit. There is no evidence to support the defendant's allegations. Thank you for your time.